All right, it's 7 o'clock. We shall begin, everyone. Good evening and welcome to the Rent Stabilization Commission meeting tonight, Thursday, May 13, 2021. I'd like to call this meeting to order. And I see Mayor Horvath join the meeting. Maybe you can lead us in the Pledge of Allegiance.
I would be honored to. Please place your right hand over your heart. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Mayor. Thank you, everyone. So we have oath of office is the next item, and we have a new person to join the commission tonight. And Madam Mayor, you are here to administer the oath of office. Yes, I am. Esteban, this is a bit different than the last time, but if you'll raise your right hand and repeat after me. I state your name.
I, Esteban Jose Montemayor,
Do solemnly swear
do solemnly swear
that while serving in the office
that while serving in the office
as a member of the Rent Stabilization Commission
as a member of the Rent Stabilization Commission
of the City of West Hollywood,
of the City of West Hollywood,
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
that I will well and faithfully
that I will well and faithfully
discharge the duties
discharge the duties
upon which I'm about to enter.
upon which I'm about to enter.
Congratulations.
Thank you.
Thank you, Mayor. Congratulations, Commissioner Montemayor, and welcome to the commission. I'm sure you will be a great addition to this commission and wish you good luck.
Thank you.
All right, I think the next item of what we have is the special order of business. I believe that's the item we have, right? Correct. So then it's special order of business. So we have a special order of business tonight, and that is the election of our vice chair. The commission will elect the vice chair due to a vacancy for a term through June 30th of 2021. And with this, I will open the nominations.
Mr. Chair,
Yes, Commissioner Marshall.
since this is such an unusual year and this term is only for less than 2 months, I'd like to see someone who has served in that position till we decide on the leadership in 2 months. So I nominate Josh Kirby's for vice chair.
Very well, thank you. Anyone would like to second that nomination?
I'll second.
All right, Commissioner, who was the first? Commissioner Copeland. All right, any other nominations? If not, Mr. Secretary, can we have a roll call, please?
Yes, Commissioner Copeland.
Aye.
Sorry. Commissioner Ayers.
Aye.
Commissioner Kirby's.
Thank you, Commissioner Maggio. Yes.
Commissioner Maggio.
Yes.
Commissioner Martz.
Yes.
Commissioner Montemayor.
Yes.
And Chair Topshin.
Yes. And congratulations, Vice Chair Kirpis. And we congrats. And now we can have a roll call, Mr. Secretary, since we have a quorum.
Commissioner Copeland,
Present.
Commissioner Ayers,
Here.
Commissioner Maggio,
Here.
Commissioner Martz,
Present.
Commissioner Montemayor,
Here.
Vice Chair Kirby's,
Here.
Chair Topchin.
Here. Thank you. We have a quorum. Next will be the approval of our agenda items tonight. Anyone would like to make a motion?
I'll make a motion to approve our agenda tonight for May the 13th, 2021.
Thank you.
I will
Commissioner.
second that.
Okay, we have the motion, Commissioner Maggio, and we have a second. I heard Commissioner Ayers, I believe. Okay. And noted. And may we have a roll call?
Commissioner Copeland,
Aye.
Commissioner Ayers,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Montemayor,
Yes.
Vice Chair Kirby's,
Aye.
Chair Topchin.
Aye. Motion passes and the agenda is approved. Thank you, everybody. And approval of minutes. Has everyone had a chance to review the minutes from the last meeting from April 22nd of 2021? We have a
Motion to approve.
I'll make a motion to approve.
That would be, I think I heard Commissioner Vice Chair Kirkus first. We have a motion and a second. Who's going to second it?
Second.
Commissioner Maggio seconded, and Mr. Secretary can waive a roll call.
Sorry, Commissioner Copeland,
Aye.
Commissioner Ayers,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Montemayor,
I abstain.
Vice Chair Kirby's,
Aye.
Chair Topchin.
Aye, minutes are approved. Thank you, everybody. Mr. Secretary, next is public comments. Do we have any speakers at this time?
Sorry, we have Eugene Maysky from CES. I'll admit him now.
All right. Since we have a public comment portion, so I'd like to begin with this disclosure that the Rent Stabilization Commission values all comments. However, pursuant to the Brown Act, the Commission cannot act on items not listed on the posted agenda. Members of the public have 3 minutes to speak. This public comment period is to address the Rent Stabilization Commission on agenda items or items of general interest within the jurisdiction of the Rent Stabilization Commission. An additional public comment period is available at the end of the meeting. With that said, Mr. Eugene Maysky, good to see you. You have 3 minutes, as I said. Just please introduce yourself, state your name and the city of residence for the record.
Hi, my name is Eugene Maysky. Good evening, Commission members. I would like to introduce myself officially. I've been a member of the Russian Advisory Board for the last 5 years, but now I'm in a different position and introducing myself in a different role. I'm a new West Hollywood Tenants outreach organizer for Coalition of Economic Survival, CES. Most of you probably familiar with our nonprofit organization. And what we do and what my role is to inform and support residents who have any tenant and landlord issues, who face unlawful evictions, dealing with harassment and other problems with their landlords, like rent problems or any other issues of displacement. So basically, I just wanted to introduce myself to you and to our tenants and let them know that we are here, that I'm here to inform them and support them and work with them and for them. And that our services include weekly tenants' rights clinic every Saturday from 10 a.m. And it's a free service that we provide that can connect the residents of West Hollywood to best tenant rights attorneys. for a free consultation. Right now, according to all the rules and regulations, we're doing it over Zoom. And during that Zoom Tenants' Rights Clinic, as we call it, WeHo residents can get a consultation with the best tenants' rights attorneys on all of their tenants' rights issues. So please let everybody know that we're here to provide this service to our residents in West Hollywood, and we are here to support them, and I'm here to support them and let them know about their rights. Thank you so much.
Thank you, Mr. Maiska, for being here, and you're certainly welcome back to the commission next time whenever you think it's appropriate to bring up issues that relate to rent stabilization ordinance in West Hollywood, the housing issues, and other matters that concerns our tenants and landlords. Thank you very much.
Really appreciate it. Thank you so much.
All right, next is our manager's report. Manager, acting rent stabilization and housing manager, Mr. Holub is here.
Good evening. Thank you, Chair. Good evening, Vice Chair, Commissioners. I'm just going to go through a few of the items that we have coming up both today and in future meetings. And I'm going to speak to the appeals separately because I had an issue come up today. I'm going to have to move that around a little bit. But coming up tonight, we've already done the election of our Vice Chair. Congratulations, Vice Chair Kerpes, on your election. Tonight, we're going to be you'll be discussing with me the tenant harassment ordinance revisions being presented by staff, along with revisions to the tenant habitability plan ordinance and other revisions to the RSO. On June 10th, we'll still be looking at the adjustment of security deposit interest formula, and an item will be brought forward for you to consider on that issue. On the 24th, the annual general adjustment will be announced. On the 8th of July, that's the time for the reorganization of the chair and vice chair for the next year. And also the committee on valuation guidelines that the commission formed will be coming back with its report on that date. And on July 22nd, anticipate bringing some regulation amendments for you to consider as well. With respect to the appeals, I just got word this afternoon that due to a staffing issue, we cannot go forward with the appeal scheduled for next week. So each of these appeals is going to be continued by one meeting. So the current appeal scheduled for May 27th will be heard most likely on June 10th. And then each one of the other appeals will be moved to the subsequent meeting. As a result, we have no agenda items for the 27th. I know that the past practice has been to only not hold a meeting when there is a lack of a quorum. So at the end of the meeting, I would suggest that before adjournment, the chair poll the members of the commission to determine whether or not they will be in attendance. If 4 wish to come, that's fine. It will be a skeleton agenda. But if at least 4 of you indicate that you will not be in attendance, then we will take the meeting off calendar and resume on June 10th. But that concludes my report. Thank you.
Thank you, Mr. Manager. Now, commissioners, do you have any questions for Mr. Holub? Commissioner Maggio, please.
Yes, Jonathan, did you say that was for the 27th of this month? I didn't hear you.
Yes, the meeting on the 27th will have no agenda items brought by staff or appeals.
Thank you very much.
Thank you. Other Vice Chair Kerpes?
I just had a question. I may have missed this. Are we still doing the presentation on June 10th on the interest? Sorry, there's a helicopter flying above. The interest security deposit?
Yes, that will still come before the commission on that date.
Thank you.
Thanks. More questions? All right. Thank you, Mr. Manager. Moving on to the commission comments. Commissioners, this is our time. All right, let's begin with, let me go around the, based on the alphabetical order. Commissioner Copeland.
Hi, thank you. I wanted to welcome Commissioner Montemayor. I look forward to working with you, and congratulations to you on your appointment, and congratulations to Vice Chair Kerpes. I hope that anyone who was not able to attend the first public scoping meeting for the housing element EIR on Tuesday will be able to attend the next one, which should be in the evening. It was a good opportunity to participate in the opinion polls and ask questions and regarding density issues and future planning. So that was very interesting, and I hope the public will be able to have some input and attend that meeting. That's all from me right now. Thank you.
Thank you. Who's next? Commissioner Ayers?
Yeah,
Anything?
my comments are the exact same as Commissioner Copeland, so I'll just say ditto.
All right. Vice Chair Purpose.
Yeah, I just wanted to welcome our new commissioner, Commissioner Montemayor. Welcome to the commission. I know you've had some experience at all of these different things, so welcome back. And can you repeat, Commissioner Copeland, can you repeat what night that you mentioned the scoping meeting was? Or
I have not gotten the announcement, the email on that yet, but when I do, I will definitely come back with that, unless someone else has gotten the word, but supposed to be upcoming soon was the last.
Thank you.
Thank you. Commissioner Maggio?
Yes. First of all, I wanted to mention and apologize that I have not been able to use the city logo because my computer will not support that background. However, I'm working on it and hopefully it will be up and running next time around. But, you know, I kind of like my own background, to tell you the truth. Also, secondly, a little Robert's rules, you know, when we nominate someone, it is not required to second the nomination. However, it's a lovely courtesy when someone does that, but it is not required.
Thank you. Commissioner Marks?
Yes, I would welcome our new Commissioner Montemayor and Mr. Kirpies on your election. And one brief note, the city is looking for additional comments and input on the Metro potential subway train station by the 28th of this month. So more input is better. I am an advocate of bringing it to our city, and the email is crenshawnorth@metro.net. Any comments, again, crenshawnorth@metro.net. And that is all I have.
Thank you. Thank you, Commissioner Marks. Commissioner Montemayor?
Thank you. And thank you all for the warm welcome. I look forward to working with all of you. I previously served on the Public Safety Commission for a few years. So it's nice to be back in service. I've lived here for the last 10 years as a renter. So I'm excited to get to work with all of you. And congratulations to Commissioner Kirpies as well.
All right, and I would just again extend my congratulations to both of you, Commissioner Montemayor for your appointment and Vice Chair Kirpies on your election. Thank you all. So since we don't have an appeals section, and we're going to move on to the new business item, which is we have only one topic to discuss under this item, and that's the ordinance revisions relating to tenant harassment, posting of notices, and requirements for production of tenant habitability plan. The commission will receive staff recommendation on this matter relating to the amendments to the ordinance, and we just need to provide feedback. No vote is needed. This is just receive and file. So with that, Manager Holup, this is your time now.
Thank you, Chair. Good evening again, Commissioners. What I'm going to do is just give a brief introduction of an overview of why this is before the Commission tonight, and then provide individual summaries of each of the four main areas that the amendments in the RSO relate to. I just think that it's probably a more manageable way to tackle this, because each part is kind of a significant portion in and of itself. So after the introduction, I'll start with the tenant harassment ordinance and just go through in the manner in which it's presented in the staff report, get feedback from the commission, and then go on to the next. and then get through all four that way. Okay, so on April 5th, 2021, the City Council directed staff to review the city's tenant harassment ordinance to determine how the language can be clarified and strengthened to more clearly outline standards for landlords and to provide further protections for tenants. Specifically, the City Council requested that staff clarify the definition of harassing conduct, enhance and specify available enforcement options, enhance posting requirements, and require tenant habitability plans for remodels that reach a certain value or number of units in multi-family dwellings. The City Council further directed staff to present its recommendations to this commission for feedback before returning to the council for its consideration. Staff reviewed the relevant portions or provisions of the rent stabilization ordinance and other jurisdictions' approach to this issue. Based on this review and staff's experiences and challenges in preventing tenant harassment, the following recommendations are presented for the commission's feedback and consideration. So starting with the tenant harassment ordinance. The current version of the city's tenant harassment ordinance was adopted primarily as a protective measure following the enactment of vacancy decontrol pursuant to what's commonly known as the Costa-Hawkins Rental Housing Act, which I know you're all very familiar with. The City Council recognized that with the advent of statewide vacancy decontrol, some landlords may engage in harassment to push longer-term, below-market tenants out of their units, and specific protections were necessary to prevent that. The fundamental framework of the city's existing tenant harassment ordinance has undergone little change since its inception. Although the ordinance has been utilized to prosecute the most egregious offenders, Council seeks to further strengthen the ordinance and tenant protections in general. I'm going to go through some of the bigger changes that are indicated in the recommendations by staff. One is to clarify that the requisite intent is to vex, annoy, injure, or intimidate a tenant, eliminating the need to show that the landlord is creating a hostile living environment or would cause a reasonable tenant similarly situated to vacate the rental housing unit. Also, to broaden the scope of when failure to perform maintenance or repairs may constitute harassment, to include such maintenance or repairs required by contract, by the state, local, or county health, housing, or safety laws, and also including the city's own maintenance requirements as set forth in the RSO. It would also further specify when entry into a dwelling unit under the pretext of Civil Code Section 1954 may constitute harassment. It would include engaging in construction or renovations of the property that creates conditions designed to encourage any tenant to vacate their rental unit as harassing conduct. And in line with that, it would include a failure to submit or abide by a required tenant habitability plan as potential harassing conduct. Specify that self-help lockouts would be a form of harassment. Specify that soliciting a tenant for sexual conduct in exchange for protection against eviction or to perform maintenance would be a form of harassment. It would also include that inquiring as to the immigration or citizenship status of a tenant or someone who wants to be a tenant with an existing tenant would be a form of harassment. Pursuant to Council's direction, we're also proposing to include the specific penalties for violation of the ordinance, which would include criminal penalties, which is already part of the code. Mm-hmm. But it would also indicate that the civil action that could be brought into the code would carry a statutory penalty of $10,000 for violation of this particular section of the RSO, as opposed to the standard $1,000 statutory damages. A suing party could still continue to seek actual damages if those are greater than the statutory penalties, and of course pursue punitive damages and attorney's fees as part of their case. So that's the scope of the tenant harassment ordinance provisions that we're recommending be amended, and I'm available for any questions or feedback.
All right. Commissioners, I'm sure you will have questions. Anyone? Because I have one. Commissioner Copeland.
Hi, thank you so much to Acting Director and to staff for all the research and work that went into this. looking into updating our RSO. The $10,000 in statutory damages for each harassment occurrence is in line with Santa Monica, Berkeley, Oakland, and what Los Angeles is currently proposing as well. But those localities also impose an additional $5,000 per occurrence if it's against a senior or disabled tenant. Is there a reason why we didn't include that added penalty that other localities have, or?
There's no specific reason, and it's certainly something that may be appropriate. And if that's the direction that the feedback that I've received from you and from even just from you, I think it's certainly something that would probably be appropriate.
The second question that I have is, it's page 28, number 10 of our packet. I'm not sure where it is of yours, but it's the sentence relating to threats of eviction made by 3-day or 30-day notices that are considered not to be made in good faith if no litigation is initiated within 30 days of the termination date in the notice. I see that's something that's marked through that we were removing. I just wondered if there was being replaced by something or if there was a reason that we were removing that.
Yeah, there's problems with proceeding with a criminal prosecution for someone engaging in preliminary steps to bring an eviction. Also, creating a rebuttable presumption in a criminal case is problematic. Let's put it that way.
That makes sense. I just wanted to find out why that was, and that's all I have right now. But thank you. Appreciate it.
Thank you, Commissioner Copeland. Anyone else? I have a quick question. I'm pretty much, I agree with everything that you just said, Manager Holub. The one thing though, can we also consider a request for some, a personal documentation or a sensitive documentation that may contain some personal or sensitive information, such as request for a social security number or a copy of your, I don't know, medical record or medical insurance, whatever. Can this type of documentation, a request, could also be considered or included in this proposal as a possible harassment?
I'll look into that. I think the only issue is that there might be legitimate reasons, perhaps in the application phase, but I get where you're coming from in that perhaps after that, if the landlord is just trying to invade the tenant's privacy, then it could be a problem. But I'll think about that some more, and if there's a way to craft an additional provision, I'll try to do so.
Correct. Yeah, maybe that's what I meant. After the tenancy was initiated, the rental application process was complete, and 5 years from that time, the owner is requesting that information. So if you can't just craft that kind of the language. Also, I'm not sure if I saw it here or maybe it's somewhere down the list I reviewed, but excessive requests to enter a unit, 24-hour notices. Sometimes we hear cases when here and there the owners would just issue 24-hour notice and they will never act on it. And sometimes tenants will get multiple notifications within a week, and the managers or landlords will not go in. So can that also be considered like unreasonable, excessive issuance of 24-hour notices to enter?
Yes, and if it needs to be sort of clarified that would be an abuse of Section 1954, I will do so.
Okay. Other than that, I'm in agreement with every item that you mentioned here, and I appreciate this very detailed explanation and the very detailed presentation on the tenant harassment. If there are no other questions, or you have questions, okay, Commissioner Mars, please.
Yes, thank you. More of a comment. We received 2 letters of correspondence, one from the Apartment Association of Greater Los Angeles, and the one, I believe, from their counterpart at the state level. Yes, California Apartment Association. I don't particularly agree with their comments specifically about if there's no available parking, the landlord's not required to do so if it's not nearby. I do, however, agree with the request for clarity, and working in this area of law, if you're not specific about what is a violation or what is not, one, it turns off tenants from going forward with things. If a tenant came to me and said, I need help with my landlord, or a landlord came to me and said, I'm having this issue with my tenant, here's the law, I may, as an attorney, just say it's not even worth going after whichever side is the problem because it's so unenforceable and ambiguous. So I think staff has done a great job crafting this with legal counsel. And what I want to do, I didn't have time yet, is to just find, there were one or two areas where I think we can tighten up the language to make it better, because our goal is to make this clear for both sides. And I think what the two apartment groups here, even if they don't particularly like the content, if we make it clear what the landlords are required to do, it's easier for them to follow the law. So it benefits everyone if we have really tight, clean language in the ordinance. And I think us as a commission have run across cases in our current ordinances where we're kind of like, what the heck did this person mean in 1987 when they wrote this? And so now is the perfect time for us to set up our future selves 20 years from now, to have some really good language to work with to help our tenants and our landlords out. So those are my comments. Thank you.
Thank you, Commissioner Marth. Great comments. Commissioner Maggio, I believe, right? You raised your hand. Did you?
I did, but I do concur with the comments that have been made thus far. Clarity is really so important. So we are not taken out to sea. So we have to be always very specific about that. I do favor, Commissioner Copeland mentioned a larger amount for seniors and those who are disabled. And yes, I'm very supportive of that. I think those individuals are vulnerable and really need, certainly under these circumstances, all the support that is possible to be given to them. Thank you.
Thank you. I don't know if it would be appropriate to also ask Mr. Manager, since you accepted the recommendation to include the disabled and seniors, can we also include in that category war veterans, and they also can be a vulnerable group that would probably need extra maybe protection and or coverage, if that would be appropriate.
I'll look into that. I think that's novel, but I'll look into it.
Yeah, just a comment, not saying that we have to. Would be great if we could. So I think if we don't have any other questions, commissioners, regarding this, or you have, I'm sorry, Vice Chair, I didn't see, oh, you know what? I squeezed my screen to see the agenda, so that's why I didn't see your hand.
I'm also having background issues, so my hand might be disappearing. I had a couple of questions. First of all, can you tell me what self-help lockouts are? I'm not familiar with that.
That's when a landlord goes ahead and locks out a tenant, basically performs an eviction without going through the proper legal procedure.
Okay, it's an odd name, self-help. The issues around parking, first of all, yes, I agree that this is, appreciate all the work that's been done on this, and I think we're moving in the right direction. It's great to see that the city is is making these changes, because it has been so hard in the past for tenants to really bring these, successfully bring these claims forward. So I'm glad to see that the city, although they're not necessarily going to be the ones prosecuting or suing, this makes it easier for the tenants, I believe. It makes it more clear, as stated earlier. The questions I had was about and kind of some of the issues that the Apartment Association of Greater Los Angeles brought up in their letter. And maybe if you wouldn't mind just addressing one of them says it's unclear, or they talk about the fact that the proposed amendment would deem failure to submit a required tenant habitability plan as harassing conduct. Is that true? And is that necessary, that alone, or is there a reason why we included that for that alone being a harassment issue?
Well, it would still have to be for the purpose of vexing, intimidating, or abusing a tenant. And one thing that staff has found was that, and I talk about, and staff talks about this in its discussion of the tenant habitability plan ordinance, is that at times of construction or remodeling, it's not always done just for that purpose. It's also done for the purpose of attempting to get long-term tenants to vacate. So if a landlord is refusing to complete a tenant habitability plan, then it means that there's a problem at the property already. And their failure to do so indicates that they don't want to engage in the necessary mitigation to protect those tenants. I only got the letters from the associations this afternoon, and I haven't had a chance to thoroughly, look at them or talk to the folks who sent them. So, I am willing to listen to anyone who has a stake in this, but the basis behind the provision is to ensure that a landlord who is, engaging in construction activities specifically for the purpose of getting tenants out or harassing them out is a grounds for finding of harassment.
Okay. And then I did have a question also on parking. Actually, even before I read the letter, I had a question on parking. I think it's certain hours during the day, the landlord would have to provide a parking pass, pay for, I think it says purchase a parking pass for the individuals or for the tenants. And then if it were at night, they would have to provide parking at an offsite location. Is there a reason why there's a separation? Why isn't it? I mean, people all over the city use parking passes to park on the street at night. And then my second part of that question is, this would not preclude a tenant from getting a rent reduction for that period for the loss of service. Is that correct?
Well, I'll take the second question first. Actually, no, with respect to a rent reduction generally. There's case law that precludes a rent reduction for work that's not going to deprive the tenant of the housing service indefinitely. So generally speaking, if it's work that's going to be completed by a date certain, then the case law suggests that you can't get a rent reduction, and B, hopefully the work will be done before you've gone through the whole process. But there are issues with actually getting a rent reduction for work that's being performed and will be completed. With respect to parking, what staff has found is that what we're concerned about is the tenants being deprived of parking during the evening hours, because that's when it becomes particularly challenging to find parking on the street. Mm-hmm. And it's not necessarily unreasonable, particularly in the seismic retrofitting cases, for a landlord to need to occupy that space for construction during the day. But what we've also found is in those cases, especially during COVID, with tenants being at home and more people working from home, that we've gotten complaints that, the parking even parking being disrupted during the day creates issues for the tenants, and it is a loss of a housing service, even if it is only during the day. So the differentiation is between where daytime parking, if they are in a permit area, the recommendation is that the landlord provide a reimbursement for the cost of that permit. But if in the unusual circumstance where the parking actually has to be taken away for 24 hours a day for a particular period of time, in that case, because it's so much more disruptive, we would want the landlord to provide alternate, parking accommodations nearby for the tenants to use. And we also want to discourage that unless it's absolutely necessary. It's very disruptive for tenants to be deprived of their parking in the evening.
And then my other question, and this is kind of in the weeds, but I think it's been a while since I've needed a parking pass, but I believe that we have free ones for like 10 days. And if we're only talking shorter periods of time, I don't want to keep property owners from doing maintenance on their properties that might be significant. And so every little cost nowadays adds up quickly. And so I just think that are we doing this to penalize them, or are we doing this to work with them to make arrangements for the tenant? I just want to stay on the making arrangements for the tenant's side rather than penalizing the landlord for doing maintenance. I think that was the last thing. I didn't agree with any of the ultimate positions that the apartment association was taking. I just wanted to clarify a couple of those things. And they also had asked for equal treatment is what they would kind of call it. But so that the property owner, or sorry, the landlord could sue the tenant if necessary, if they were being harassed. Nothing in this ordinance prevents a landlord from taking any legal action towards a tenant for this type of conduct, right? That they describe in their letter.
Well, this ordinance is not intended for that, but it doesn't preclude a landlord from pursuing other remedies, I suppose, if they're being, there's other ways to deal with harassment just between individuals outside of the landlord-tenant relationship. But this is specifically a tenant protection measure because of the potential for the power differential and the fact that it came into existence because of vacancy decontrol. And there's an incentive among some, not many, I hope, but among some landlords to try to do it in a way that they shouldn't.
Yeah, I think that we all agree there is an incentive, whether they act on it or not, that's different. Yeah. Thank you. Again, great job.
Thank you, Commissioner Montemayor, and then Commissioner Ayers.
Thank you. I agree with many of the comments that were made. I think this is great. So I thank staff for all their work on this. I had one comment or question. I know that the ordinance contemplates or recommends mention of immigration and citizenship status. I was wondering if it would also behoove us to include language around First Amendment, legally protected First Amendment right activities.
You mean like posting of political signs or something?
A political sign or something to that effect.
Yeah, I'll look into that. I understand the point, and I'd want to look into the issue a little more before saying I can craft something that would be appropriate for this ordinance, but I'll definitely look into it and see if it's something that would be appropriate for this specific part of the RSO.
Wonderful. That was my only comment. I agree with the comments from my colleagues, and I also didn't agree with the two letters that were sent with us, but I appreciate their input.
Thank you. Commissioner Ayers?
Yeah, thank you again to staff for putting together this amazing document. I think these are the kind of things, ways to strengthen tenant rights that the City Council was looking for. I agree with Commissioner Copeland as far as perhaps writing in an additional penalty for tenant harassment actions against seniors and disabled tenants. I like that idea, and since it's being done in similarly structured cities, that's something that I think would be appropriate in ours. And I just wanted to clarify just one thing. Under the section, what is it, 17.52.090, prohibition of tenant harassment, B, harassment includes but is not limited to the following conduct done with an intent to vex, annoy, injure, or intimidate a tenant. So as far as like determining what a landlord's intent is that something that is determined by the hearing process? Because obviously no one can crawl inside the mind of a landlord and know what the intent is, but certainly actions can create a story about it. So I guess that's my question, is how is that intent determined? Is that just part of something that's done during the hearing process?
Well, these generally wouldn't be heard. They wouldn't be heard in the hearing context. As the ordinance indicates in the proposed revisions, violations of these provisions that are being proposed would go through either a criminal prosecution or civil litigation. Whether with a criminal prosecution obviously be brought by the people, but would be investigated by staff and presented to the city prosecutor. So the intent component of that criminal case would have to be established beyond a reasonable doubt in a trial, assuming it went to trial. In a civil litigation, it's a different standard, but nonetheless, it would be borne out by the evidence. And again, if it were the city that were initiating the litigation, then that investigation would be conducted by city staff and presented to our city attorney for their determination as to whether or not a recommendation should be made to proceed. And of course, in the case of a private citizen, such as a tenant who believe that they were aggrieved as under this ordinance, then they would proceed with civil litigation. So this would not arise in the administrative hearing context. It would only, although staff could make certain administrative determinations with respect to tenant habitability plan requirements, but that is subject to review by the director if someone feels that they shouldn't be required to do engage in the tenant habitability plan as a result of their conduct.
Thank you. That clarifies things greatly for me. I don't have any additional comments. Thank you.
Thank you. Commissioners, any more questions? Vice Chair, yeah.
I just had one more question, and I think I forgot it, but it had to do with, the number of units, the posting portion, posting notices in the common areas, and I believe it was specific to the postings for the non-rent stabilized units, the units that are for 1947, the maximum. I'm sorry.
The state law limit.
Yeah, I didn't quite hear you, but
I'm sorry.
So is there a reason? There's a reason why it's 5 units and above, and I just thought that was odd.
I was going to ask, is this the next portion of?
Is this the next
discussion? Yeah, we want to finish the tenant harassment part.
I'm sorry.
Yeah, that's okay.
I'll wait.
So relevant questions.
Be thinking about your answer.
Yeah, if we don't have any other comments or questions about the tenant harassment portion of the introductory report, maybe we can move on to the posting requirements for some notification.
Yeah, and that is next. I'll just give the brief synopsis here. The RSO currently requires that landlords advise rent stabilized tenants at the start of their tenancy that the tenancy is governed by the RSO. the notice has to be presented in English, Spanish, and Russian. For properties with 5 or more units, and this is the existing law, the notice must also be conspicuously posted in a common area of the property. In order to fulfill the council's direction to enhance the posting requirements, staff is making the following recommended revisions. Add the following language to all posted notices as follows. This property is also subject to Chapter 17.52 of the City of West Hollywood Rent Stabilization Ordinance, which includes but is not limited to the protections related to eviction and the prohibition against tenant harassment. Require posting of notices all exempt new construction. That's a relative term, but those are properties that for which a certificate of occupancy was issued after July 1st, 1979, with 5 or more units that advises tenants that they are also protected under Chapter 17.52, and whether or not the property is subject to the rent limitations of Civil Code Section 1947.12, which is a relatively new state law limiting rent increases for properties that are more than 15 years old. Require that all notices now have the Department of Rent Stabilization's phone number. Require that all notices be posted in English, Spanish, and Russian. And if this passes, the city will, of course, provide that. And that all violations of a posting requirement would be subject to the administrative remedies, or commonly known as a citation, provisions of the code. So, and I can just go right ahead and answer your question, Vice Chair Kerpes. There's 2 reasons. One is it's precedent. That's been the requirement since the beginning. Posting has not been required at properties that are 4 plexes or less. And the reason staff is recommending continuing with that is there are issues with posting at smaller properties. There just might not be the space. More of our properties consist of more than that number of units anyway. So on the other, to counterbalance that, the division sends out I'm sure you're aware, a twice yearly newsletter. And I fully anticipate that, provided these things pass or in some form pass, that staff would be including that in our newsletters, certainly in the short term and perhaps over the years, to advise tenants. And there's a tenant newsletter and there's a landlord newsletter that goes out. So they would be adjusted depending on who it's going to.
Yes, Vice Chair, continue, please.
Yeah, just to follow up on that, thank you for answering that. I didn't realize that was already the precedent. That's what we were following. I was worried that we were confusing the new law with 5 and above units and not and thinking it didn't apply to units of buildings of 3 units or a duplex. So I'm glad you clarified that. Are we instead requiring that the landlord provide that upon the start of the tenancy for under 5 units? Like 5 units.
Yeah, that is not what's currently required. Is that a landlord inform a tenant if their unit is not rent stabilized? But I think it might be time to, based on where you're headed, I think it might be time to look at that provision as well, and see if we might want to adjust that too. So that just like rent stabilized tenants receive notice at the beginning of their tenancy that they're in a rent stabilized unit, regardless of the size of the building, perhaps we should adjust the notice to tenants in non-rent stabilized buildings to conform to this, so that even if you're in a smaller building, you're getting the information you need, at least at the outset.
I think that'd be helpful, especially with the new state law that not necessarily all tenants are aware of, that puts a cap on annual rents. Thank you.
Thank you. Other commissioners, any questions regarding the RSO notification posting on the property? Commissioner Copeland and then Commissioner Maggio.
Hi. As far as posting, I did read the letters that we received this afternoon as well, and there was a comment about it being burdensome on property owners to do the posting. And I think with the city providing if I'm correct, the city will provide these notices that have to be posted upon request, right? So they would just have to post them, not print them or come up with any of the verbiage themselves. They can request it from the city. So I don't
Right.
really think that taking a few minutes to put it in a conspicuous place is burdensome. And the posting is very important. And we have a lot of tenants who come from other states, from other countries, who's never lived in a rent regulated city. And when they arrive, they're not sure what that means, some of them, and then they hear about it. Well, is my building covered? Is it not covered? And I think this posting is a great way to clarify right from the beginning, even to potential tenants, which buildings are covered and what they cover, and the phone number for rent stabilization as well. So very happy to see the posting update included. So thank you for that. That's all.
Thank you. Commissioner Maggio, please.
Yes, I was going to elaborate also on the posting. I'm a great supporter of posting, even if there is less than 5 units. You could always find a place to post. And it makes it very obvious, helps to clarify some of the questions that probably would need to be asked in other ways. But I would hope we could post units under 5. Thank you.
Thank you. Other commissioners, any more questions? Thank you, Vice Chair Kirkus. These were my questions that I wanted to also ask. But since Manager Holub already explained and Commissioner spoke in favor of having maybe something changed that would require some sort of information or posting on the property, or directly given to the tenant at the time of signing the rental agreement, renting the unit, disclosing this is a rent stabilized unit, because I think the whole idea, the main idea of doing that is to educate the tenants about their rights. And I agree with Commissioner Copeland's comments that a lot of tenants are not from this area. I mean, not a lot of tenants, we don't know. There could be tenants that are not from this area, not from LA, not from any other rent control jurisdiction. They're not familiar with the RSO or any protections, right? So I think that's one of the main purposes of the posting when the city council adopted that provision, that law, is to educate and to make people aware they reside in a rent stabilized unit that provides protections from unlawful evictions and unlawful rent increases. And also, and the tenants also have obligations, obviously, under the law. So I'm in favor of making sure that whether it's through posting requirement, maybe that can change, or just adding something else that the tenant will receive at the time of renting a required kind of a notice that this is an RSO unit. Because the rent stabilized units are those, as a reminder to people who are watching us, these are the rent stabilized units are those that have properties that have 2 or more units with a certificate of occupancy before July 1st, 1979, basically built before July 1st, 1979, with more than 1 unit, which is basically 2 or more units. So I really want to make sure that tenants who live in the buildings with less than 5 units also know about these protections. So that would be basically my comment in favor of that. Also, Mr. Manager, what is the enforcement process of failure to post the notification? Can you just explain?
Sure. Were this to pass council, what I would anticipate is an education campaign at first. Certainly, I wouldn't want to immediately go into citations. The purpose behind this is not to cite people. The purpose behind this is, as you pointed out, to educate. So I would anticipate, unless directed by council, to do something different, perhaps a year-long education period, utilizing our website, our mailings, and whatever other community engagement we can come up with. And even then, if a landlord is found to be out of compliance, and this is consistent with code enforcement practice, to give them a warning before issuing a citation, and perhaps even providing a form for them to post. So the idea is to get the posting up there, not to punish. But for those that refuse, after that period of education and warnings, then a citation would issue.
So there is no administrative hearing process for this type of violation, right? There's no reduction.
A citee can always appeal the citation. So if they disagree with the finding of whichever city employee issued the citation, then they can appeal that. But there's no preliminary hearing. It's just a staff observed violation, and then the citation is issued.
Okay, so my question was basically, if the tenant, if there is no compliance or there's no, due to failure, can the tenant file a complaint and pursue a rent reduction, or that's not an option because of the?
They can. That's another option. Hopefully, with a more robust enforcement mechanism, that wouldn't come up as much anymore. But tenants have brought the failure to post as a grounds for rent reduction and have been awarded reductions because of the failure to post. But we would prefer that the instead of a rent reduction being awarded, that the notice just go up.
I see. All right. Yeah, that concludes my questions and comments, commissioners. If you have any other questions, if not, we can move on to the next part of your presentation, which is the tenant habitability plan ordinance, right? I think that's the last part.
There are some technical amendments.
Yeah,
which I'll go over quickly when we get to the end. But we've already touched on a few of the issues related to the tenant habitability plan ordinance. Just a bit of background. This ordinance was adopted in 2018. And it came back primarily in conjunction with the mandatory seismic retrofit program that the city implemented. But at that time, division staff was also becoming aware of a growing trend of developers buying rent-stabilized properties to remodel and flip. This would often create construction zone conditions that appeared sometimes intended to drive out long-term tenants. In order to address these situations, the provision governing the production of a tenant habitability plan allowed staff to make an administrative determination that a landlord produce a plan when activities created untenable conditions or ran afoul of the tenant harassment ordinance. Mm-hmm. Consistent with the council's directive and to avoid the need for a determination after the work has already begun, because that's what's been happening, and that's the way the ordinance works right now, where we've got to wait till we see a problem. The following recommendations are being made to prohibit any issuance of a permit until staff, determined by the director, determines that the permit is sought for work at the property that will cause any occupied residential rental dwelling unit to be uninhabitable under the housing, health, building, or safety laws of the state of California or the city of West Hollywood, or that the permit is sought for work at the property where the landlord has engaged in any of the conduct enumerated as harassing under the tenant harassment ordinance within a prior 12-month period, that the permit is sought for any remodel, which shall be defined as any improvement to more than one dwelling unit or the common areas at a multifamily residential rental property within a 12-month period that would materially increase rental value in a normal market, and or that the permit is sought for work that will result in all elevators being inoperative for more than a 72-hour period. So the ordinance would just continue to require a plan for seismic work. And we are also recommending further revisions based on our experience over the last 3 years in dealing with producing these plans. We do find that in certain situations, a plan might not be required. A lot of the seismic contractors are quite skilled at working around the tenants and really don't create big problems. So we've developed a checklist to see whether or not the work would require a plan. And we just want to codify that so that landlords who don't need to produce one shouldn't have to produce one. But at the same time, we found in those more problematic cases that staff needs flexibility to determine what additional mitigation measures might be required. Because every case, particularly those cases that are problematic and create a lot of disruption, are all unique and need to be addressed individually. So that's the scope of it.
Thank you. Commissioners? I wanted to ask, just maybe just confirm or maybe clarify. So the tenant habitability plan, the THP, is required only when the work would require permits, right?
Right. I mean, the work that doesn't require permits, that truly doesn't require permits, is usually of a very limited extent. So it wouldn't trigger the requirement.
Like minor work, again, minor things that may be painting the kitchen cabinets. That something
Right.
like that wouldn't probably require a work permit.
And even if it requires a permit, like I mentioned, it would still have to fall into one of these categories before a tenant habitability plan would be required. Where the intent is not to overburden landlords or staff with excessive planning requirements. It's just to capture those projects that are big, although legitimate, and to monitor those properties that are found where this might be some more nefarious intent.
Okay, great. I think this is great. I think this is terrific. Thank you. Commissioner, Vice Chair Kurpis.
So the question, is there a fee associated with habitability plans?
Yes, there is now. The City Council just passed a fee. It's $100 to have it filed and reviewed.
Okay, thank you.
Thank you. Commissioners, any other questions? All right, so we don't have other questions. So Mr. Hollop, you may continue.
Thank you. So there's just a few sort of cleanup changes that we're proposing as well. With respect to tenant work for housing services that have been eliminated and a rent reduction's been applied, there are certain cases where tenant can do the work themselves. And there's just was some sort of difficult language in the ordinance that surrounding financing of those projects. It's just simpler to require that the tenant be reimbursed for reasonable financing if they do the work. There's essentially old language related to the requirement to have a resident manager in buildings with 16 or more units. The original language, which was written at the time of the passage of the ordinance in the mid 80s, anticipated that they should have an opportunity to wait for a vacancy, but that was quite a while ago. So the requirement that they have a resident manager for buildings with 16 or more units, staff believes that that should be happening by this point. One of the changes specified that an on-site rental payment amenity is a housing service that cannot be unilaterally eliminated. This does tie into tenant harassment. We have found some situations where it is possible that when a new owner comes in who's doing perhaps some of the work that we were talking about before, suddenly requires that the landlord, that the tenant mail the rent, which can lead to its own forms of mischief. Not saying that it's always intended to do that, but a lot of tenants are used to, and it certainly is an amenity to have the ability to have a drop box, at the property. And so we want to discourage changes to that amenity for tenants who have it. It adds that the failure to post resident manager business hours and emergency telephone numbers will subject the landlord to administrative penalties. So this is just adding another enforcement mechanism to the RSO, in addition to the ones we discussed earlier that allow for the issuance of a citation if a landlord does not post the required postings that are already required by the RSO. But this allows for an enforcement mechanism. And we also need a clerical correction related to the ability to issue an administrative citation. The one area of the RSO that allows for an administrative citation to be issued, and granted, I'm not aware of one ever being issued. It relates to what we were talking about before, where a landlord is required to let a non-rent stabilized tenant know that they're in a non-rent stabilized unit at the outset of the tenancy, and a citation could theoretically be issued. So we're not going to change that. We're just cleaning up the language because it references a provision of the code that is not correct anymore. So that concludes my report, and I'm available for any additional questions or feedback.
I really like that on-site payment amenity, that clarification and the requirement to keep that original method of payment, because especially if there are any seniors or disabled people, they're not really, maybe not that familiar with, or they are unable to go to the post office or mail it or do online payments or something. That's an important, I think, the service that they have to pay on site, and that's a great thing to do, to include this. Overall, I'm really happy to see that this work was done. Yeah, but that's my comments. Commissioners, anyone? All right. So
I think
that,
we report and file this now. I would.
Right. So I was going to say that is if Mr. Manager, there are no other things that would like to clarify, mention, or add, then we'll just, for the record, we'll say I received and filed, and I'm sure that you will share with, you'll prepare the recommendations that are made by the commissioners, so for the city council to consider them at the next meeting whenever you're going to present this to them. And thank you very much. This was really great, and thank you. And I want to thank your staff and the legal division for doing such an amazing job with this document and the recommendations. Thank you. Thank you for bringing it to the commission.
Thank you.
I don't see we have anything else under new business item. And next is public comments. I don't know if, Mr. Secretary, we have anybody waiting?
None at this time.
Not at this time. All right, commissioners, next is our comments. Commissioner Macho?
Yes, I'm sorry to the new commissioner. I've been remiss. I didn't welcome you. I usually do it at the end. I want to see what a job you're doing. But welcome, and I can't wait to see you all dressed up in council chamber. I'm hoping that's going to happen very soon. In fact, I hope the manager will help us to answer that question. Will we be back in chambers in July?
All right, Commissioner Copeland?
No answer?
Yes, I do. Oh, I'm sorry. I think he's still waiting for a response for.
I'm sorry, I was going to address it.
Oh, I thought he's going to address, yeah, but that's okay.
If I get any more things, I'll address them all in the comments. How about that?
Okay.
All right.
All right, so Commissioner Copeland?
I just wanted to thank our acting housing director, Holub, and staff once again for such a thorough report and all the work and research that went into it. And I'm very happy to see us updating our rent stabilization ordinance and tightening our tenant protections. Your home should be your sanctuary. That's the one place you should close the door and feel safe and at peace in. So I'm very happy to see this, and welcome again to Commissioner Montemayor, and congratulations again to Vice Chair Kirby. So that's it for me. Thank you.
Thank you. Commissioner Ayers? Anything?
Not much to add, just congratulations on the vice chair, Commissioner Kirby's, and welcome Commissioner Montemayor. And yeah, I'm also interested in when we can get back to council chambers. I've been double vaccinated. Any information you need from all of us to help you make that happen, I welcome. Thank you.
Thank you. Commissioner Martz, I don't see your hands, or I see it, so you're kind of far away. Vice Chair Kirpis.
Yeah, I just wanted to say thank you. I didn't mention earlier, thank you for the election. And thank you, Commissioner Maggio. Kind of caught me off surprise tonight. I wasn't even paying attention to the fact that we were filling a vacancy for the vice chair. So I appreciate that from all of you. And I don't know if I said it in the past. Hopefully I did, but if I didn't, or if I did, this is the second time. If I didn't, then I want to let Manager Holub know that that how much I appreciated both the elevator and the tenant not temporary relocation reports and presentations you did to the council. I thought that they both took our comments and you put them together very well in the presentation. Whether all of them were accepted or not was irrelevant to me, but just the fact that the way you presented it gave the council the option, and council was fully clear on which things may have came from us and which things may have come from staff. So I really appreciate that. It's great to see that, and I'm sure that that will continue on and on this one as well. And I think, and to answer the question earlier about May 27th or 29th, our next meeting, if there's nothing on the agenda, I probably will not be, I will not be able to attend. I'll start.
You will not be able to attend, you said?
I will not be attending,
Okay.
yes.
Okay. Yeah, I was going to ask it later, but I think maybe this is appropriate to ask the commissioners at this time to make those, confirmation if you will be able to attend. But let me go to Commissioner Montemayor for his comments first.
No comments for me other than thank you for the warm welcome and thank you to staff again for the robust revisions to the ordinance. I too won't be able to make the meeting.
Okay, so who else will not be able to make it on the 27th? Commissioner Maggio?
Unfortunately, I will not be able to attend the May 27th meeting, but I'm looking forward to seeing everyone 2 weeks later.
Anyone else?
I will not be able to either. Thank you.
Okay, so since we already have 4 commissioners, they acknowledge they will not be able to attend the 27th meeting. We'll probably not have that meeting on the 27th, but let me go to the next item before I adjourn the meeting with announcing the date of the following meeting. I would like to hear from staff at this time.
Thank you, Chair. First of all, I'd also like to welcome Commissioner Montemayor. Welcome aboard, and it's great to have you here. I look forward to working with you. Also thank the Commission for their feedback and other comments tonight. It's very helpful. I appreciate it. Regarding the chambers, getting back into chambers, I don't know. I'm not, I can inquire. I'm not responsible for that decision. That's a higher pay grade, I think, ultimately. But I will try to find out. And as soon as I know, I will let you all know. Hopefully sooner rather than later. But look forward to seeing you all in person again when it happens. And that's all I have. Thank you.
Thank you, Mr. Manager. All right, so then I will adjourn this meeting until the next regular meeting of the Rent Stabilization Commission that will be held at 7 p.m. Thursday, June 10th, 2021 via teleconference. So we will not have a meeting on May 27th. So thank you, everyone. Have a good night and
Good
stay
night.
safe.
Thank you.
Good night,
Bye-bye.
everyone. Take care.
You too.